Hi, this is Anita Josiah, the Cook County In-Home Support Program Coordinator. At this time, we're going to talk about HIPAA, data privacy, and staff responsibilities. As you proceed through this video, be sure you have a pen and paper available. From time to time, you will see a note beginning with the words writing task. At those times, please pause the video and take a few moments to reflect and make a few notes. I will be asking you to submit those notes as proof that you've completed this training. Thanks. Information in this video regarding the Health Insurance Portability and Accountability Act is based upon the Health and Human Services website noted here. You may access that website if you like for further information. The Health Insurance Portability and Accountability Act of 1996, or HIPAA, H-I-P-A-A, usually pronounced HIPAA, was created to improve the efficiency and effectiveness of the healthcare system. It included provisions that required Health and Human Services to adopt national standards for electronic healthcare transactions and code sets, unique health identifiers, and security. Provisions were incorporated that mandated the adoption of federal privacy protections for individually identifiable health information. There are several rules as part of HIPAA. The first one we will talk about is the privacy rule. The privacy rule was begun as of December 2000 and later modified in August of 2002. The privacy rule sets national standards for protection of individually identifiable health information by three types of covered entities: health plans, healthcare clearinghouses, and healthcare providers who conduct the standard healthcare transactions electronically. Compliance was required as of April 14, 2003 or April 14, 2004 for small health plans. The security rule was created in February 2003. The security rule sets national standards for protecting confidentiality, integrity, and availability of electronic protected health information. Compliance of the security rule was required as of April 20th, 2005, or a year later, April 20th, 2006, for small health plans. The enforcement rule contains provisions relating to compliance and investigations, imposition of civil money penalties for violations of HIPAA administrative simplification rules, and procedures for hearings. The Omnibus Rule implements a number of provisions of the Health Information Technology for Economic and Clinical Health, or HITECH Act, to strengthen the privacy and security protections for health information established under HIPAA. This Omnibus Rule was enacted as part of the American Recovery and Reinvestment Act of 2009 to strengthen the privacy and security protections for health information. The HIPAA Breach Notification Rule requires HIPAA-covered entities and their business associates to provide notification following a breach of unsecured protected health information. A breach is an impermissible use or disclosure under the privacy rule that compromises the security or privacy of the protected health information.
Make no mistake, attackers are after the personal information your organization stores. Data breaches regularly expose millions of personal data records, which criminals use to commit fraud or identity theft. When a security breach results in a privacy failure, it's not just an internal problem. Laws like HIPAA and GDPR give data subjects the right to know what's happening with their personal information and impose stiff fines on organizations that fail to protect data privacy. So exactly what does it mean to protect data privacy? It means handling personal data with respect for confidentiality and anonymity. This applies to all data related to individuals, such as their names, birth dates, addresses, social security numbers, financial data, and medical records. Failing to ensure data privacy can cause lots of trouble. Even a single leak of personal data can have a serious impact on your organization's financial well-being and its reputation, since public, investor, and customer trust can be irreparably damaged. To protect data privacy, you need to understand what data you have, where it's located, and who can access it. Visit netrix.com to get started today.
Hello, my name is Jill.
And I'm Casey Davis.
Today we will discuss the 8 various topics of HIPAA. First, we will answer the question, what is HIPAA? HIPAA is the acronym referring to the Health Insurance Portability and Accountability Act, which was enacted in 1996. HIPAA is designed to improve efficiency and effectiveness of the healthcare system. The Department of Health and Human Services, Office of Civil Rights administer and enforces the law.
There are 5 main purposes of HIPAA: to provide continuity and portability, to combat fraud and abuse, to provide uniform standards, to reduce administrative expenses, and to ensure security and privacy. Now we will take a look at a quick overview of HIPAA.
In 1996, the U.S. Congress enacted HIPAA, or the Health Insurance Portability and Accountability Act. This act governs the use, transfer, and disclosure of health-related information. One of the requirements of HIPAA is the protection of protected health information, known as PHI. PHI is defined as any piece of individually identifiable health information, such as a person's medical records or healthcare payments. The protection requirement applies to organizations like ours that store, process, or transfer patient information in electronic, paper, or oral form. The HIPAA regulations have been amended and updated many times. The most significant update happened on February 17, 2009, when President Barack Obama signed the American Recovery and Reinvestment Act of 2009 into law. This included the Health Information Technology for Economic and Clinical Health Act, also known as the HITECH Act. The HITECH Act is the same law that created the Electronic Health Records Incentive Program, as well as the HIPAA Breach Notification Rule. The Breach Notification Rule requires that covered entities and business associates must provide notification of a breach to affected individuals, the Secretary of the U.S. Department of Health and Human Services, and, in certain circumstances, the media. Safeguarding PHI is an important regulatory requirement for organizations like ours. In the video Data Security, you learned steps for protecting sensitive information. The same steps apply to protecting PHI. However, there are some additional steps that apply when you handle PHI. Only share patient data with authorized personnel who have a need to know. You must obtain the individual's written authorization for any use or disclosure of PHI that is not for direct care or treatment. A central aspect of HIPAA is the principle of minimum necessary use and disclosure. You must make reasonable efforts to use, disclose, and request only the minimum amount of PHI needed to accomplish the intended purpose of the use, disclosure, or request. In addition to these regulations, there are other healthcare regulatory groups who produce information security guidelines to protect patient privacy and safety. Entities such as the Joint Commission, also known as JCAHO, and the U.S. Food and Drug Administration publish their own standards and best practices for how an organization should protect PHI. It is important that our organization remains compliant with industry and regulatory standards. By respecting these guidelines, you help ensure that our organization protects PHI and we remain compliant with industry and regulatory standards.
After viewing the little presentation here about HIPAA, please pause the video and take a few moments to respond to the writing task. We are here looking at the Cook County In-Home Support Program Data Privacy Policy. a copy of which you have in your service provider manual. This data privacy policy is provided to service recipients when they enroll in services, as well as annually after that. And you yourselves are trained on data privacy annually. And as I said, have a copy of this as well. I would encourage you to go to your service provider manual and read this more thoroughly. I'm just highlighting kind of a summary for the purpose of this training. So the In-Home Support Program recognizes the right of each person receiving services in this program to confidentiality and data privacy. Private data includes all information on the persons, and only the following persons are permitted access to that private data: the individual themselves or their legal representative, anyone to whom they give signed consent, employees of the welfare system whose work assignments reasonably require access to the data, anyone the law says can view the data. Welfare data is private data on individuals. Once informed consent has been obtained, there is no prohibition against sharing welfare data with other persons or entities within the welfare system for the purposes of planning, developing, coordinating, and implementing needed services. So in our case, only for the planning, developing, coordinating, and implementing the services of the In-Home Support Program. Data created prior to death remains in the same legal classification even after their death. As for providing notice at the time of service initiation, the service recipient and his or her legal representative, if any, will be notified of the program's data privacy policy, as I mentioned earlier. At the time informed consent is being obtained, we must tell the service recipient or their legal representative why the data is being collected, how the agency intends to use the information, whether the individual may refuse to furnish that information, any consequences for refusing to disclose, how they can see and get copies of their data, and any other rights regarding information collected. A proper informed consent or authorization of information form must be written in plain language, be dated, designate a particular agency or persons who will get the information, specify the information which will be released, indicate who will release the information, specify the purposes for which the information will be used, contain a reasonable expiration date, and specify any consequences for signing the form. So in our case, you each receive copies of releases of information that the service recipients have signed on your behalf so that you can work with them in the home and communicate with myself or Martina or their case manager. So you are familiar with those forms, and I always provide you with the initial release of information. They are renewed annually, even though I don't give you a copy every year, since it's the same except for the expiration date. So the designated coordinator, which is myself, manager, my supervisor Martina Johnson, and service providers. As far as our access to private data, we do not automatically have access to private data about the person served. Any written or verbal exchanges must preserve confidentiality, protect data privacy, and respect the dignity of the person whose private data is being shared. Generally, doubts about the correctness of sharing information should be referred to myself or Martina. Individuals or their legal representatives have a right to access and review their individual record. Myself or Martina, designated coordinator or manager, will make an entry in their progress notes when that happens. An individual may challenge the accuracy or completeness of information, and we would then refer them to the grievance policy for lodging a complaint. They are provided a copy of our grievance policy at enrollment, and you also have a copy of that in your service provider manual. Individuals may request copies of anything in their record. No individual, nobody, may permanently remove or destroy any portion of the person's record. A service recipient's case manager, if they have one, or in the case of other programs like ours that are under the same licensure, foster care program licensors do have access to the records. If we're requesting information from other licensed caregivers or primary healthcare providers, there's another release of information form where it is listed very specifically what's being requested, clearly identifies the recipient of the information, assures informed consent of the individual, and keeps the document in the service recipient's record. This data privacy policy is updated on a regular basis. Whenever Department of Human Services has updated the information, then we also update our policy to stay consistent with their requirements. You are now looking at the In-Home Support Program Release of Information Authorization form. On this form, the individual will be releasing information to be shared with others. It begins at the top with the individual's name, and then the statements: in order to provide services to you, this program may need to obtain information from or share information with other individuals, programs, or providers. This program needs information to provide you services. If this program does not get requested information, or if we cannot share information with others who work with you, this program might not be able to provide you services you may need, or this program's assistance may be hindered. Also, this program may not be following government laws or regulations, and that is if we do not have the release of information form. Here on this line, most of the time it's going to be the service recipient's name. In some cases, the service recipient has a legal representative who it signs for them, so then it might be that person's name in that situation. So individual or legally authorized representative, either request or authorize the in-home support program to exchange information with. You have seen a similar form as this with your name on it as service provider, so it may be so that you and I can communicate, and you can communicate with my supervisor in my absence. So authorize the in-home support program to exchange information with you. It may be the person's emergency contact. It may be our department, especially if they have a case manager. And anybody that the individual wants information to be shared with might be here. It might be a friend or family member, or another program such as Care Partners in some cases. Types of records that would be released: potentially oral and or written, generally for the purpose of provision and coordination of services and or in the case of an emergency. And then by signing the form, they are stating they know that state and federal privacy laws protect their records. And they say, I know why I'm being asked to release this information. That will be discussed with them at the time the form is signed. I do not have to consent to the release of this information, but not doing so may affect this program's ability to provide needed services to me. If I do not consent, the information will not be released unless the law otherwise allows it. I may stop this consent with a written notice at any time, but this written notice will not affect information the program has already shared. And then the persons or agencies who get my information may be able to pass it on to others if there is a legal reason for that. And then if my information is passed on to others by this program, it may no longer be protected by this authorization. This consent will end 1 year from the date I sign it, unless the law allows for a longer period. So generally, this form is filled out for appropriate people or agencies at the time of enrollment, and then each year when the individual meets for the annual review each year, they will again sign release of information forms. So let's say this was signed in December 2020, it would expire in December 2021, and at that time it would be rediscussed and a new form would be signed. And so at the bottom is the signature of either the person or their legally authorized representative and the date. In summary, briefly, HIPAA restricts access to private individuals' health information including confidentiality, integrity, and availability of electronic protected health information. Honoring data privacy respects confidentiality and anonymity of individuals. Cook County in-home support service providers should know and follow the program's data privacy policy. Take a couple moments now and complete the final writing task. And thank you for participating in this program. Thank you.